Okay, since we're tight on time today, we're going to get started while folks are still coming in. Thank you, everybody, for joining us. My name is Maeve Malik. I'm a partner on Hunton's global data, cyber, and privacy team. And my colleagues, Danielle Dobrusin, who is counsel in our New York office, and Peter Birghoffer, who is an associate in our San Francisco office. We're collectively very, very excited that you are here and that we're going to talk today about data minimization and some hopefully practical tips and best practices for actually implementing this concept within your organization. In terms of minor administrative details, please note that this program is being recorded. We also wanted to flag that if you have questions throughout the program, please use the Q&A feature at the bottom of your screen, and time permitting, we will attempt to answer those by the end of the program. So Vani, could we please move to the next slide? Thank you. So just very quickly, the agenda for today, we're going to start by talking a little bit about what data minimization actually is, and then we're going to focus on U.S. data minimization requirements and enforcement under primarily the state comprehensive consumer privacy laws. We'll then move to a discussion about the other side of minimization, which is data retention. Talk a little bit about some of the data security considerations that arise when we have data minimization on our plates, and then finally talk about some of the challenges and solutions to actually implementing this principle in practice. So with that, I will turn it over to my wonderful colleague, Danielle.
Thanks, Maeve. Bonnie, you can go to the next slide. One more slide, Bonnie. Yeah, perfect. So let's start off by setting the foundation here and defining what we mean when we talk about data minimization. So data minimization is the principle that organizations should limit their collection and retention of personal data to the minimum amount necessary to serve a specific business purpose, or in some cases, purposes reasonably related to that purpose. This principle has long been a core tenet of data protection law. In the EU, for example, the GDPR requires that the collection of personal data be adequate, relevant, and limited to what is necessary in relation to the purposes for which they are processed. Some US state privacy laws also impose a duty of data minimization, which we're going to talk about more. And data minimization requirements appear globally in data protection laws in jurisdictions such as Brazil, Canada, India, Japan, and Singapore. Now, data minimization is a relatively broad principle, and it can seem overwhelming or difficult to put into practice when thinking about it in general terms. So I think it's helpful to think about how we can apply this principle more specifically through different lenses. For example, data minimization may look different when applied to consumer rights requests or cybersecurity or AI training. And we're going to walk through some of these lenses in this webinar. I also want to address some of the key risks that data minimization is intended to address. You may have heard the saying, more money, more problems. Well, the same can be true for data. Excess collection and retention of personal data can expose organizations to significant risks, such as higher compliance burdens. For example, it can be extremely difficult and costly to operationalize consumer rights requests, like access and deletion rights, if a company maintains mass amounts of personal data in multiple systems. Also, non-compliance with legal data minimization requirements obviously can lead to potential regulatory penalties, and public enforcement actions or complaints can cause reputational damage to an organization. Apart from legal compliance risks, organizations also experience higher operational costs for maintaining larger volumes of data. And I'll also say that storing and processing excessive data can lead to redundancy and cluttered or inaccurate record keeping. It's like when you have too many clothes in your closet and it becomes harder to figure out what to wear. Here, not having insight into the data that you have means that less value is extracted from that data. And then finally, excess data can lead to greater increased attack surface for cyber breaches and greater regulatory and financial exposure. And Peter's going to talk about that more. Next slide, please. I also want to run through some of the core principles of data minimization. These are the do's and don'ts for organizations. First, collect and use personal data only as necessary to accomplish an identified and lawful purpose. Relatedly to that, don't collect personal data just because you think it could be useful at some point in the future. For example, if someone is completing a purchase online, there's certain data you obviously need, like shipping and payment information. But it may not be appropriate to collect things like gender or demographic data in those contexts. And then I'll also note, we often see teams within organizations want to hold on to data because it could be useful for some undefined future purposes. And it's like an episode of Hoarders where the person is saying, but I might need it someday. In reality, if those purposes are materially different from the purposes disclosed to individuals at the time of collection, for example, in a privacy notice, you're not going to be able to use the previously collected data for those purposes anyway, unless you obtain consumer consent. Next, keep personal data only in secure, approved locations, and ensure that you don't create unnecessary copies of data, as this can lead to inconsistencies. Retain personal data only as long as necessary and useful, which Maeve is going to speak to more. And finally, delete or de-identify personal data when it's no longer necessary. And this determination should be based on clearly defined internal guidelines and rules. Next slide, please. And we can go one more, yeah. So let's move into the US requirements. The US is, of course, a complicated landscape from a privacy perspective, with different rules under different regimes. But we'll walk through some of the key examples of US data minimization requirements. First, we'll start with California. The CCPA has a prescriptive and unique data minimization and processing limitation provision. The law says a business's collection, use, retention, and sharing of a consumer's personal information shall be reasonably necessary and proportionate to achieve 1, the purposes for which the personal information was collected or processed, or 2, another disclosed purpose that is compatible with the context in which the personal information was collected. Otherwise, a business needs to obtain consent to the processing. And then the CCPA's implementing regulations expand on this to say that the purpose for which the personal data is collected or processed must be consistent with the, quote, reasonable expectation of consumers. And the regulations provide a number of factors to consider in determining the reasonable expectation of consumers, such as the relationship between the consumer and the business, the nature, type, amount of personal information, and then the source of personal information. So this goes beyond just making sure that a purpose is listed in a privacy notice. Businesses need to actually evaluate how consumers would expect the business to collect and use their data. Next, we'll talk about Maryland. The Maryland Consumer Privacy Law has introduced a strict data minimization limitation that we have not seen in other comprehensive state consumer privacy laws. MODPRO provides that a controller must limit the collection of personal data to what is reasonably necessary and proportionate to provide or maintain a specific product or service requested by the consumer to whom the personal data pertains. So this can seriously limit an organization's ability to collect personal data in situations where the consumer may not realize personal data is being collected. And it can also cause friction with the ability to collect personal data from third-party sources, particularly if a consumer does not have an existing relationship with the organization. The Washington and Nevada consumer health privacy laws use a standard similar to Maryland's, but are limited only to consumer health data. And they also provide for the ability to obtain consumer consent if the collection of consumer health data is not necessary to provide a product or service requested by the consumer. With respect to other states, many of the state consumer privacy laws lack specific data minimization requirements related to the collection of data, but they do include general processing limitations that prohibit controllers from processing personal data for purposes that are not reasonably necessary to or compatible with the disclosed purposes for which personal data is processed, unless the controller obtains consent. I'll also flag a potential standard under the newly proposed Federal Secure Data Act, which would draw on GDPR language and require controllers to limit the collection of personal data to what is adequate, relevant, and reasonably necessary in relation to each purpose for which the data is processed as disclosed to the consumer. And then finally, we have seen data minimization principles reflected in a number of regulatory enforcement actions, including from HHS, NYDFS, the FTC, and the FCC. Next slide, please. Now, I want to take a bit of a deep dive into California's data minimization enforcement efforts. What we've seen to date is that California enforcement actions look at data minimization through the lens of exercising privacy rights. So first, in April 2024, the California Privacy Protection Agency, known as CalPrivacy, issued an enforcement advisory about applying data minimization principles to consumer rights requests. And in short, the advisory makes it clear that businesses need to request the minimum amount of personal data necessary to effectuate a request. And for access, correction, and deletion requests, businesses also need to request the minimum amount necessary to verify the individual's identity. The advisory also makes it clear that requests to opt out of the sale of personal information or the sharing for cross-context behavioral advertising purposes are not verifiable requests. So companies should only collect the minimum amount of data necessary to effectuate those requests and not verify them. About a year after the enforcement advisory, CalPrivacy announced an enforcement action against Todd Snyder. CalPrivacy alleged that Todd Snyder's web form required consumers to provide a photograph of the consumer holding their identity document to submit any rights requests, including opt-out requests. And first, like we talked about, opt-out requests are not verifiable requests. And then even for verifiable requests, CalPrivacy said that the company unlawfully required consumers to submit more information than necessary to exercise their rights. So this action really drilled down on the data minimization message delivered in that initial enforcement advisory. And with that, I'm going to pass it over to Maeve to talk about data retention.
Thanks very much, Danielle. Can we move to the next slide, please? So Danielle just spoke extensively about one side of data minimization, which is primarily data collection. But another side of this coin is limiting retention of that data. And this is where we start to talk about channeling our inner Marie Kondo and thinking about getting rid of data that's no longer serving our business. There are a number of different considerations that go into determining data retention periods, and I'll just highlight a few here. So kind of table stakes, we have applicable legal requirements. So there are the various data minimization rules that Danielle just covered. There are also literally thousands of sources of legal requirements around records retention in the US and abroad that govern how long organizations have to retain different types of business records that may or may not include personal data. In the US alone, there's over 13,000 different sources of records retention requirements at the federal and state level, which is a little bit different than the more limited set of data minimization rules we see among the states. There's also other considerations such as retaining certain data to address potential statutes of limitations if we're expecting litigation. There are considerations like legal holds and other preservation orders that may actually prevent us from disposing of data before a certain period of time. And then depending on your business model, you may have applicable contractual obligations that require you to either retain data for a certain period of time or destroy it when the contract has expired. But legal considerations are not the only thing to take into account here. We also have to think about business need. Businesses need data to conduct their regular activities and think about strategic future plans. There's also the increasing challenge of needing data in order to implement and train AI models, particularly homegrown AI models. And then we also have to think about and balance the cybersecurity risk. And I won't spend too much time on that because my colleague Peter is going to speak about that in a minute. But there are lots of different cybersecurity risks associated with over retention of data. And the level of risk is really dependent on a number of factors specific to any given organization, including the industry you're in, what's happening in the cyber threat landscape at the time, the types of data you're storing, what other compensating safeguards you have in place, and so on and so forth. Danielle mentioned that some privacy laws have specific data minimization requirements. Some of these also require you to state your data retention periods or the criteria that you use to determine data retention in your public-facing privacy notices. And then beyond that, the challenge then becomes, how do you do what you say you're going to do, right? So baseline is including that information in your privacy notice, but how do you make sure you're not making a material misrepresentation when it comes to actually disposing of data when you say you will? And what we have seen time and again is that perhaps the most effective way to implement limits on data retention is to establish a comprehensive records management program. And we'll talk about this a little bit more towards the end of the presentation when we start talking more about practical challenges and solutions. But just a preview for you, even though records management, which refers to business records, is slightly different than retention of data, which refers to things more like personal data, we have seen time and again that companies that have mature records management programs and actually follow through on disposing of records when they are no longer needed for business or legal purposes reduce overall the amount of data that they are maintaining on their systems, purely because data tends to reside within those records. So I'm going to turn it to Peter now to talk about data security. Can we go to the next slide, please?
Great, thanks, Maeve. Can we? Yeah, perfect. So the main takeaway from this slide is that consistent data minimization practices reduce cybersecurity risk. They make incidents less likely, and if a data breach does occur, they enable a simpler, faster, and less costly response when compared against an organization that collects data indiscriminately. As Maeve mentioned, data minimization presents a dilemma for organizations that view more data as a source of greater knowledge and ultimately greater business value. So the challenge is to find the minimum amount of data that enables your business objectives without creating unnecessary risk. It's important to find this balance because overcollection can significantly increase your organization's cybersecurity exposure. Specifically, overcollection creates a larger attack surface and burdens incident prevention. If there is more to target, the threat actor is more likely to succeed. But if your organization is good at reducing the amount of data it maintains, and this includes duplicate data, it can reduce the potential impact of a data breach. If an incident occurs, a larger pool of affected data and individuals complicates the response. In other words, you can think of data minimization as one of many safeguards organizations should implement to help reduce the likelihood and the impact of a cybersecurity incident. Over-retention increases the likelihood that the incident will be notifiable. In general, an organization that maintains a robust data minimization program is less likely to have large quantities of legacy personal information that serves no business or legal purpose, but will nevertheless trigger notification obligations. In general, breach notification laws are agnostic about when the data was collected. They only care if the data elements fit into the prescribed categories of notifiable personal data. The date of collection is immaterial. I should add that focusing on essential data also allows organizations to allocate resources more efficiently to protect critical information. Now, even if notification is required, a smaller volume of affected data likely means fewer potential plaintiffs, fewer jurisdictions in scope, and overall a lower likelihood of regulatory scrutiny. But while a data minimization program does more than organize files or remove excess data, it's also aimed to improve your organization's understanding of its own systems. And if your organization understands its systems, that could speed up the investigation, the response, data mining efforts, all of which lower costs. We have seen time and again organizations spend hundreds of thousands or even in excess of $1 million in data mining and legal fees to figure out what is in the stolen repositories of data. And I'm going to name a few typical scenarios that could be interesting. The first is we have seen companies that maintain legacy files of personal information, including social security numbers dating back to the 1960s and 1970s. We have also seen companies with entire servers full of terabytes of unstructured data that had to be categorized through months of data mining. And we have seen companies who believe they only collected certain defined categories of personal information and were later surprised to learn that their employees marked down a lot of additional sensitive data in a free text comments section of the affected database. In each of these examples, an underlying cybersecurity incident created higher than expected costs for the organizations. Beyond that, there is also the risk of erosion of consumer trust. But the good news is that a comprehensive data retention program can also help prevent these outcomes. Data minimization is a concrete and effective step your organization can take to limit cybersecurity risk and associated costs. If you can avoid overcollection and you implement robust processes for the routine disposal of data that you no longer need for business or legal purposes, you can mitigate the legal, reputational, and financial risk associated with potential data exposure in the event of a cybersecurity incident. The key thing then to remember is that you don't have to protect and pay for the data you don't collect and store on your systems. And with that, I'm going to turn it back to Maeve now. Can we move to the next slide, please?
Great. Thanks so much, Peter. So in our remaining 9 minutes, let's talk a little bit about why I assume everyone is really here, which is what are some of the barriers to actually implementing data minimization at scale, and then how do we break through those barriers? So I won't, just in the interest of time, cover every single item on this slide, although I do think that it's a pretty good overview of what we tend to see when we're working with clients who are struggling with these issues. But I want to highlight a few just to start. So number one, there is obvious and value in amassing data as an organization. And this is particularly true for certain industries like retail and hospitality, where customer data is really critical to driving business success. Data sets have inherent value. We often hear people talk about data being the new oil. It flows freely and it's extremely valuable for organizations. And particularly as we're seeing the advent of AI and more companies start to develop their own homegrown AI solutions, we see and we fully recognize that having data sets and large quantities of data is very important to achieve those business objectives. But some of the challenges that we see, so one would be legacy systems. We often see organizations really just not have a great sense of where data resides within their network. There's often legacy systems that folks have forgotten about over time, or that people thought maybe were cleaned up at some point, but actually weren't. The unfortunate part is that sometimes these come to light when you have a cybersecurity incident, and those have been affected. But that's definitely a barrier we see to implementing data minimization at scale, is just not knowing where the data resides. Relatedly, we also see a lot of organizations have complex or unstructured data repositories, basically just servers that are full of things like unstructured Excel spreadsheets and PDFs and PowerPoint presentations and things that may have a lot of data in them, but that aren't easily categorized because they don't fit neatly into structured tables with headers that we can clearly see what's in there or how much is in there. I also want to talk a little bit about pressure to keep data for potential future use and institutional or stakeholder resistance to data disposal. So my colleagues touched on this a little bit, but a lot of times what we see is there's a real push from either the legal department or the privacy team or both to move toward data minimization and really get serious about records management and data disposal. But you get a lot of pushbacks from executives or others in the business who sort of say, well, I really rely on, for example, my old emails from 10 years ago, or I am hesitant to delete all of this because what if a client comes back with a project that's relevant to something we did 5 years ago, something like that. So really breaking through that cultural resistance to data disposal and starting to shift folks' mindsets about the benefits of data minimization is a very, very common challenge, but one that I would argue is not insurmountable. I really believe that with appropriate training and stakeholder education and education about the risks, like we've all been talking about, we can move the needle forward in a meaningful way. There's also always the problem of insufficient resources, and then also competing legal requirements where, you might want to get rid of something because it's taking up too much space or too much, it's costing too much to retain, or you think it poses too big a security risk, but then you have legal requirements that are saying that you need to keep it. So if we could go to the next slide and talk about what do we do? I would say first step, if you haven't begun to address data minimization in your organization, is to actually inventory the types of data that you have and where it resides. And this is not a small task. We fully recognize that this can be overwhelming, but if you take it incrementally and start with, the core systems that are sort of the crown jewels of your organization and figure out what they include and how far back that data goes, that can be a really good place to start. And then you can sort of look toward the ancillary or legacy systems, once you have a good process in place for doing that. It's also very important to keep track of the regulatory landscape. So Danielle highlighted some of the US requirements. And of course, for companies that operate globally, there's also competing global requirements around data minimization. And it's important to stay on top of those, and particularly stay on top of enforcement actions to understand how regulators are approaching this issue and what some of those enforcement risks are given your organization's size and industry sector and similar factors. It's also important to make sure that you have good data governance. So making sure that someone in the organization or some team in the organization has responsibility for this task. I will tell you, in our work doing records management, we often see that the folks assigned to be the record stewards are not the most popular, and we are sympathetic to that. But it is a really important task. And again, with that kind of stakeholder training and education, we've seen meaningful change in really getting people to understand the importance of this topic. Part of data governance is obviously written policies and procedures and making sure that those are being adapted to changing regulatory requirements, but it also has to do with building in data minimization by design. So before new products and systems launch, having that be part of your privacy impact review process, for example, to figure out, are we truly collecting the minimum amount of data that we need to actually run this product or service, and what is our retention period for the data within this solution. And then, as I mentioned before, our records retention program can be a really helpful place to start. These are usually composed of two parts. One is a policy that governs how records within the organization are created, stored, and ultimately disposed of. And then a retention schedule that identifies the different categories of records that the business maintains and addresses the legal requirements and business need for when you can dispose of those records. And then when you implement a system for reliable and regular disposal of unnecessary records, and you apply appropriate retention policies to systems that contain those records and that data, you end up in a really good spot to have a defensible approach to data minimization, where if you're ever challenged, you can say, we have these processes in place. We address the risks to data by managing the records that our business maintains. And we follow, and this is very important, we actually follow what our written policies and procedures say, so that we're not just saying what we do, but we're doing what we say. With my 1 minute remaining, we do have a question in the Q&A box about records management. So someone has asked, is there a resource for best practices for aligning records retention with applicable law? Well, we like to think you're looking at them. This is a kind of project that our team regularly helps companies manage. But there are legal reference resources out there that consolidate those 13,000 plus different sources of records retention requirements, so that companies can better understand what their obligations are. And then, but of course, that's only one piece of the puzzle. The other piece of the puzzle is making sure that you're taking into account business need and sort of the culture within your institution of how willing people are to part with their records. Thank you, everyone, for joining us today. We really appreciate your time and attention. And if you have any questions after the program, please do feel free to reach out. Our contact information is on the slide. Thank you again.